Test one, check one. Test two, check two. Test three, check three. Test four, check four.
Smith. I'm a partner here in Morgan Lewis in Philadelphia. Thanks everybody for coming. We are honored and happy to be hosting our friends and colleagues from the Public Interest Law Center and beyond to have a great presentation here today, and thanks everybody for coming. So with that, I'll turn it over to Ellen Friedel, who's going to give some opening remarks. Just swap.
Thank you, Colby. On behalf of the entire Board of Directors of the Public Interest Law Center, welcome. Many thanks to Morgan and to you, Colby, for generously hosting us today so that we can come together to explore an issue so fundamental to our democracy. Morgan has long supported the Law Center. Morgan lawyers have served on our board, like Colby, provided many hours of pro bono legal services, and also provide generous financial support for our work. Without the wonderful support of Morgan Lewis and our other donors and volunteers, many of whom are here today, we would not be able to do our very important work. The Public Interest Law Center's mission is to use high-impact legal strategies to advance the civil, social, and economic rights of communities in the Philadelphia region facing discrimination, inequality, and poverty. We use litigation, community education, advocacy, and organizing to secure access to fundamental resources and services. We pursue that mission in a variety of areas, including education, employment, healthcare, environmental justice, housing, and of course, voting. Our voting rights practice has long been a focus at the Law Center, and we have a track record of demonstrated success, including defeating Pennsylvania's discriminatory voter ID law, which would have disenfranchised hundreds of thousands of voters, and improving access to adequate polling places for residents of Lower Oxford Township and Lincoln University. We are currently continuing the fight for voting rights through our lawsuit challenging how congressional voting districts are drawn. And that brings us to what we are all here today to explore. I'm delighted to introduce Ben Geffen, Law Center staff attorney, who will moderate our panel presentation, Straight Talk on Crooked Lines, the Impact of Gerrymandering on the Democratic Process. Ben works across the Law Center's practice areas, including voting rights, employment law, healthcare, and access to public records. Ben's successful cases, and there are many, at the Law Center have included a challenge to Pennsylvania's voter ID law, a Pennsylvania Supreme Court case about access to Medicaid payment records under the Right to Know law, numerous matters involving the rights of children with disabilities, employment discrimination against people with criminal records, and educational equity. After college, Ben spent several years working in the nonprofit sector in Boston. He then, after law school, clerked 2 years for the Honorable Robert M. Levy in the United States District Court for the Eastern District of New York. Ben serves as a mayoral appointee on the Philadelphia Police Advisory Commission. He is a graduate of the New York University School of Law and Princeton University. Ben, you're up.
Thank you, Ellen. And thanks to all for coming out today. A few years ago, if we'd advertised an event about gerrymandering, I don't think we would have gotten this full of a crowd. But it's a really important issue right now that has deservedly gotten a lot of attention. And I'm really glad that everyone is here today to hear from an outstanding panel of some of the leading thinkers and doers on these issues in Pennsylvania and nationally. Michael Lee you'll hear from first. He's senior counsel at the Brennan Center for Justice at NYU School of Law. His work there focuses on redistricting, voting rights, and elections. Prior to joining the Brennan Center, he practiced law at Baker Botts in Dallas for 10 years and is the author of a widely cited blog on Texas redistricting and election law issues. In addition to his election law work, Mr. Lee previously served as executive director of B1 Texas, a donor alliance that oversaw strategic and targeted investments in nonprofit organizations working to increase voter participation and engagement in historically disadvantaged African American and Hispanic communities in Texas. He received his JD from Tulane Law School and his undergraduate degree from UT Austin. Next, we have Carol Kuhnholm, who is the chair and co-founder of Fair Districts PA. Fair Districts PA was founded in December of 2016 by representatives from Common Cause of Pennsylvania, the League of Women Voters of Pennsylvania, and a number of other groups, including Committee of 70. I see we have a couple of Committee of 70 folks in the House today, too. Fair Districts PA current focus is on amending the Pennsylvania Constitution to replace the current partisan redistricting process with an independent, impartial Citizens Redistricting Commission before the release of the 2020 U.S. Census results. Ms. Kuhnholm is also on the board of the directors and serves as vice president of government and social policy for the League of Women Voters of Pennsylvania. The League of Women Voters of Pennsylvania is the organizational and lead plaintiff in our redistricting case that's going on right now. She's also on the board of directors of the League of Women Voters of Chester County. She holds a bachelor's degree from Houghton College and a PhD from Penn. Finally, Duell Ross is on his way here. He was on an Amtrak train from New York that got stuck, but he is now in Philadelphia and will be here any moment now. He is assistant counsel at the NAACP Legal Defense and Educational Fund. He joined LDF as a Fried Frank Fellow, working with both the political participation and the education practice groups. He worked for 2 years at Fried Frank, focusing on complex commercial and civil rights litigation, and before that served as a law clerk for the Honorable Roger L. Gregory on the Court of Appeals for the Fourth Circuit. He's also been a fellow at the ACLU's Racial Justice Program. He received his JD from Penn Law School, where he was executive editor for the Journal of Law and Social Change, and he studied business and public policy at Wharton as well. And he received his BA from the University of Southern California. So with no further ado, take it away, Michael Lee.
Sure. I can hop over there. Thank you, Ben, and thank you all for having me here to talk about redistricting and gerrymandering in particular. My job on this panel is to talk about partisan gerrymandering and the litigation that's going on around the country, including here in Pennsylvania. And it's a subject that's been much in the air of late, and not the least of which because next week on Tuesday, the Supreme Court hears oral arguments in Gill versus Whitford, which is the first partisan gerrymandering case to reach the Supreme Court in over a decade. And it will give the court a chance to finally say whether there are some bounds to gerrymandering, or conversely to say that gerrymandering is something that courts shouldn't even deal with. But there's also a number of other cases that are coming through the pike, and I'll talk about those. And in some ways, I wish Duell were here. I had a joke at his expense, but I'll have to make it in his absence. But in some ways, he has the easier topic because he's going to talk about racial gerrymandering and the Voting Rights Act, and that's because those are areas where there isn't the sort of vacuum that we have in the partisan gerrymandering context. And my job is easier because the Supreme Court really has left us with this giant vacant space, and virtually anything that I or Ben or anyone else could say about partisan gerrymandering wouldn't be entirely wrong. It wouldn't be far from the mark. Duell just has to deal with a line of cases that Pam Carline at Stanford has called borderline incoherent. I don't have that problem. I don't have any cases that sort of actually establish doctrine. But saying something meaningful and predictive is perhaps a little bit harder. And what I want to start with is what gerrymandering is, and it's a subject that people oftentimes talk about, but it's sort of a catch-all phrase, right? And it encompasses a lot of things. And I often tell people that gerrymandering isn't one thing. It's like cancer. It's many things, right? You have skin cancer, you have lung cancer, you have brain cancer, and they're all related and they're all bad things, but they have different causes. They have different symptoms and they have different cures. And it's important not to think of everything as that you don't like about maps or the redistricting process as gerrymandering in the exact same way. And what the cases that are moving through the courts, with one exception sort of, deal with is what we call extreme gerrymandering. And that is where one party locks in a disproportionate share of seats, essentially entrenches a majority for itself that is immune and impervious to the election cycle, right? And so there are two sort of elements to that as a practical matter in terms of talking about practical harm. One is the party has to sort of get a large block of seats and a majority. And the second is that it has to lock that in, right? It's not a problem if a party has a large block of seats, but the course of elections changes those seats. They flip hands between parties. That's healthy democracy. But what is unhealthy is where one party, as in Pennsylvania, has 13 out of 18 of the congressional seats, and not a single seat has changed hands all decade, or North Carolina, where Republicans have a 10-3 majority in that state's congressional delegation, and only one seat the whole decade has changed hands. And that's what we mean by extreme gerrymandering. And it's important to sort of also understand how this occurs as a practical matter. A lot of times when people think about gerrymandering, they think about making districts ultra safe. But that's really not how you do an extreme gerrymander, right? If your party is winning districts by 80%, you haven't been very successful as a gerrymanderer. What you want to do instead is you want to spread your voters out as much as possible among districts so that you win a whole bunch of districts. And so what you want to do is you want to draw 55, 45 districts, or better yet, 53, 47 districts, or 52, 48 districts. And that way you're winning a bunch of seats. Now, of course, there's a danger in that, which is that if you draw the districts too thin, your party is vulnerable to a wave election. And it used to be, as a result, that people would draw these gerrymanders and they would build in a little bit of safety. They would say, okay, let's go to 56 or 57, but we won't go below that because then we're sort of creating too much risk. But as a result of better data, as a result of more information about voters, it is possible to draw districts thinner and thinner and know that they will stick. And that's what's made the gerrymanders of this decade that much more pernicious and harmful. And that's what you've seen in a handful of states. So by our estimates, there are about 6 or 7 states on the congressional side and maybe just under a dozen states, state house or state senate chambers, that have this problem. And lo and behold, it almost always occurs in a battleground state, which is sort of the last place in some ways that you would expect. But it sort of makes sense because battleground states are those states where you have, in many parts of the state, a fairly even spread of partisans. So if you were to look at a precinct level map, you have a lot of pink, you have a lot of light blue. And by artfully slicing and dicing and recombining voters, you're able to engineer districts that perform the way that you expect. That's the problem that these cases are getting at. A little bit in the way of background, many of you will have heard of the case Veith v. Jubileer, yes, the hardest case in the world to pronounce, and I'm still not convinced. I had an assistant who told me his mother's name was Veith, but they pronounced it Veith. So I don't know exactly how you pronounce it, but Ben perhaps could tell us. So that was a case out of Pennsylvania, and the court famously sort of deadlocked 4-4-1 for the justices, led by Justice Scalia, said the issue was one that courts couldn't even consider. the four liberal justices at the time came up with several different standards which were inconsistent with one another, and Justice Kennedy wasn't ready to strike down Pennsylvania's congressional map, but wasn't ready to put partisan gerrymandering out of bounds either. Sort of a classic Justice Kennedy role, like I don't know, and so that was 2004, and since then, a lot of people have felt that you could really sort of go to town on this, and that's led to sort of the gerrymanders of this decade. In terms of sort of what the constitutional harm is, right? I mean, a lot of people have focused in the gerrymandering context on what the court said in Veith was the need for a manageable, discernible standard. And so a lot of people have interpreted that as, aha, we need a mathematical test. And there hasn't been a lot of partisan gerrymandering litigation, for the better part of a decade, but there has been a lot of work on developing more statistical measures to sort of get at the problem. And there are things like the efficiency gap, the mean median difference, the seats to votes curve, but literally dozens of others that have been designed to do that. But it's important to understand, of course, if you're trying to get partisan gerrymandering struck down, that you actually have to sort of violate something in the Constitution. And what that something is, it could be the First Amendment, it could be the 14th Amendment. It probably is really sort of a fusion of the two in terms of in terms of what the constitutional harm is. And really, I would posit that there's sort of two values out there. One is accountability, and the idea that if seats can't change hands, that's a problem, the entrenchment problem. But there's also representativeness, and that's sort of a deeply rooted value in our system. If you go back to John Adams talked about how legislature should be exact portraits or miniatures of the people, and Congress should be that as and what you have when you have 13-5 like you have in Pennsylvania, which is a 50-50 state at almost every statewide level, you don't have that. And it's in 10-3 in North Carolina isn't representative of North Carolina, and so all of the voices that are there aren't there. And that gets at something that really, frankly, is a fair, even predates the Constitution, the idea that there shouldn't be taxation without representation. And by that, they just didn't mean sort of nominal representation. Everybody has a member of Congress that they could technically get at. What they meant was that the bodies that make this decision should be broadly reflective of the people. And that's, after all, why we have elections every 2 years, right? I mean, the idea, that's much sooner than many jurisdictions, and so in many countries, the idea is that that the Congress and the legislature should be close to the people. So after the court deadlocked in Veith, they had another chance in a Texas case, Lulac versus Perry, to sort of make some headway. They basically punted on the issue, and since then, a lot of people, including Neil Gorsuch in a footnote in a case in Colorado, seem to suggest that the issue has been, that you could basically do anything. In North Carolina, famously, this last decade, the Raps got struck down as a racial gerrymander. They came back and said, we're going to do a political gerrymander because we can do that. They drew, one of the express criteria was that they had to have 10 Republican congressional seats. When asked why 10, they said we couldn't figure out a way to draw 11. And so a big case in Wisconsin is setting that up. In addition, right after the Wisconsin case gets argued, there are a couple of cases in North Carolina challenging that congressional map that are going to trial on October 16th, the day after Gill versus Whitford gets argued. There's a big hearing here in Pennsylvania, which you'll hear more about. There also is a case out of Maryland that could set all of this up. But this is a really big moment for our democracy, and in part because the technology is getting much more pernicious. Things that seem space age today will seem run-of-the-mill in 2021. If you think about all of the big data that's available to campaigns and marketers, based on who you Google, where you shop, where you travel, all what magazines you read, all of that will make it possible to draw maps with that much more precision. And that also today, unfortunately, has a huge racial ramification, right? The Supreme Court has put racial gerrymandering and, of course, intentional discrimination out of bounds. It hasn't done that with partisanship, and so this decade you've seen across the South legislatures defend maps on the basis that we weren't trying to discriminate against African Americans or Latinos. We just were trying to discriminate against Democrats, and lo and behold, they happen to be African American and Latino. And that's a real problem in a world where the court has created this false binary of it's either race or politics. Let's set aside the issue of whether it could be both at the same time. But the court has set up this false binary. It has to be one or the other. And that's led to this sort of defense. And now that the Supreme Court also has gutted Section 5 of the Voting Rights Act, there is a lot of concern that if you don't sort of have a break against partisanship, that defense will have greater and greater. You'll hear it made more and more, and it may be very hard to defend the rights of minorities. So not only are things about to get much worse, but there's also some real-world ramifications that go simply beyond even representativeness to sort of fairness for communities of color. So I'll stop there. I'm sure there are lots of questions. I'll be happy to answer those afterwards.
Thank you, Michael. And we are going to have time at the end for some Q&A. So please save your questions. There will be an opportunity.
Thank you for coming to think about this topic. I got involved in this as the election reform specialist for the League of Women Voters at the time, late 2015. I was looking at our elections and saying, there's a lot that needs to be addressed. What's the most timely and the most impactful? And I should have stopped and said, and what would be the most difficult? But I didn't ask that question. So I'm going to be talking about Pennsylvania, and you have had a chance now to really study this map. And if this map doesn't make you angry, you're missing some things. Our congressional maps are drawn as a piece of legislation, and we know those maps are not drawn by people who are thinking about you. They're drawn by party leadership in DC and then handed over to our legislator, and they're told to vote for the map. And we know leadership on both sides are actively involved in creating districts for people that they like, and we know that the Republicans the last time did carve out 13 out of 18, despite the fact that we are a swing state. So we know that we are one of the most gerrymandered in the country, and this District 7 is often, well, anytime you see a list of top 5 or top 10 most gerrymandered districts in the country, that will be one of them, and affectionately called Goofy Kicking Donald. Another name is Bullwinkle. Somebody has called it Spin Art. People make up names for these things. The issue is not the shape, though, as Michael can tell you. The issue is not the shape. It's what's happening in the shape, what's the intent behind the shape. And I say you can't understand District 7 unless you look at it with Districts 6 and 16, and especially look at Montgomery County. There on the right, Montgomery County by number should have its own congressional district. It should have one congressman or congressperson. And instead, because Montgomery County is probably one of the most swing counties in the country, it is carved very, very, very carefully into the areas around it. So Montgomery County actually has 5 congressional representatives. One of them lives in Montgomery County. I had a conversation recently with somebody who said, oh, don't worry about this because, okay, so District 7 goes through 5 counties. The way it's done is that everybody has a representative. They might not live in their district, but Montgomery has a representative. Now I look at that and I think, to think that that's okay is really, really, really troubling. I actually live in District 6, kind of right where District 7 wraps around it. But then look at District 16. Now look at this little thing up in the top there. That's Reading. See that? So let me make sure you see this, because this is what's going on here. That little weird thing up there in the top, that ear. So the crime to me is not so much District 7, it's what's happening in these districts. And look up there, I'm going the wrong way. That weird thing is Reading. Now, if you know anything about Reading, 2010 census, Reading had the highest share of citizens living in poverty in the nation. Yes. I've had people come up to me after, I've done many of these presentations now, and there's often someone who'll come up and say, that's not accurate. And I'll say, here's my card. Get back to me. And I'll get an email the next day saying, I apologize. It is accurate. And Reading School District has consistently been one of the most underfunded U.S. school districts in the country. Many times it is the most underfunded. Now, there's lots going on in Reading, and I'm not saying the fact that Reading is gerrymandered in that crazy way is the only problem in Reading, but who is thinking about Reading in Congress? Or if you look at their state district maps, the same thing has been done. There is no one anywhere in any legislative body who is looking at a community like Reading and saying, let's solve this. No one. So the east side of the state loves to talk about how we have the worst districts, but go to the west side of the state, look what happened to Erie. Now, Erie is an angry place. You know how Erie voted in the last election? Erie feels like no one is listening to us. Well, I went and spoke in Erie, and by the time I was done, the people were like, this is why. This is why. Look what they did to us. Erie should be one congressional district, spilling out a little bit into the regions around it. And instead, Erie is chopped in half, so it has no voice at all. That District 5 goes all the way down to State College, which also has no voice, because all there is between there is red countryside. So there's a lot of anger when people feel like they're not being heard, they feel like they're not being represented, they don't know why. When you show them a map and you say, who represents you? They say, oh. So we've been growing across the state. We have, last check, we've had 220 meetings where we have explained this to citizens from Erie to Philadelphia to Pike County to Beaver County. We've had, I think the last count was about 14,000 people show up at these meetings. We're trying to educate people about this deep intrinsic wrong in our system. So the congressional districts are drawn as a piece of legislation. Our House districts are drawn by 5 people. So each party leader chooses another party leader, and those 4 then are supposed to choose a 5th. If they can't agree, then they choose someone from the state Supreme Court will choose the 5th. So basically you have 5 people deeply invested in the situation, deciding what those lines should be. So again, people say, oh, it's the congressional districts. You don't have to worry about the state legislative districts. Well, there's Erie's House districts. See anything odd going on there? You've got this industrial waterfront region that has no voice. They very deliberately cracked out District 1, actually, they couldn't figure out how to get rid of that, so they actually have some representation. And the rest are all cracked out into the areas around them. This is Butler County. Look at what's going on. Slippery Rock, there's a university there. Beaver, look at, there's 4 districts. See that? If that doesn't make you angry, you're missing the point here. Now, people have said, as Michael said, gerrymandering's been going on for a long time, but it's changed. It's gotten much, much, much worse. So this is District 7 over time, and you can see it went from being a little odd to being extremely odd. And what's changed, as Michael said, mapping technology, data mining, undisclosed outside money coming into our state legislative races to capture the process. So in 2010, Karl Rove, and I just need to say, I am nonpartisan, League of Women Voters, completely nonpartisan. This is a nonpartisan conversation. We're just simply recounting the facts. In 2010, Karl Rove said, he who controls redistricting can control Congress. That's not politically correct, the he, but it is accurate. There are never women in the room when this happens. These are men in a back room controlling the process. He who controls redistricting can control Congress. And the idea was, if we throw some money into state legislative districts to flip where we can to control the state legislature, then we can capture more seats so we can control Congress. Congress is the prize, right? You want to be able to decide what happens in terms of trade, what happens in terms of regulation, what happens in terms of healthcare. It's in Congress. So the goal is to capture our legislative districts, throw some money towards them. So RedMap 2010 was launched and was greatly successful. Nearly $1 million was spent in PA House races. That's a lot of money for PA House races, targeting and flipping 3 to control our congressional redistricting process. So if you haven't read this book, I won't say the title, by David Daley. It came out since I started doing this, and I said, I wonder if it has anything about Pennsylvania. I should have known. The first chapter about any state is about Pennsylvania, and there's another chapter about Pennsylvania describing the harm to the electoral process, to the citizens, and the toxic nature of this kind of process when that kind of money is thrown into our state legislative races, not for the good of the citizens, not to identify the best candidates, none of that, simply to capture Congress. In the next round, it will be worse. There are 3 PACs, super PACs, already identified by the Democrats: Unrig the Map, Advantage 2020, the Obama Holder Movement. Look at the graphic there. Recognize that? We are top of the target in this little game. And of course, Red Map 2020 will be doing the same thing with 125 million. They've upped it by, my math is bad, they multiplied by 10. So it will be worse the next time around. And why are we a target? We're one of the few remaining large swing states, as Michael said. This only works if you're a swing state. That's the only reason to do this extreme gerrymandering. You need a swing state. We have very, very bad, as in non-existent, campaign finance laws. We have ranked 43 out of 50 for electoral integrity. And the other reason is we have a large legislation. I don't have a slide for this. We have a large legislation, which means that the races are relatively inexpensive. So you can take $1 million into our races and you can get the best bang for your buck, which the head of the Red Map Committee said when asked, where did you get the best bang for the buck? He said, by far, Pennsylvania. I hope you feel good about that. Brennan Center for Justice came out with some rankings. In 2 of their rankings, in terms of extreme gerrymandering, in 2 of them, Pennsylvania was the top. In the 3rd, we were the next to the top. And Philly.com Inquirer pulled together a nice graphic to show where we stand in the others. In any way that you measure, we're among the worst 5. 2 of the forms of measure were the worst, and then the other were the next to the worst. There's a study that came out just a couple weeks ago. How am I doing? 3 minutes. I'm going to have to skip right by this. Read this study, please, Why Competition in the Politics Industry is Failing America. Michael Porter from the Harvard Business School Competitiveness Project and Catherine Gale did some work to show how our dysfunctional legislature is having a huge economic impact. And it's very much worth looking at. I don't have time to talk about it, but they talk about devastating impacts on citizens. And then another study came out 2 weeks ago. I also don't have time to talk about, but don't read this one. It's very long. But read the executive summary. The Pennsylvania Economy League came out with a study talking about the fiscal distress in our communities in Pennsylvania. And what they say was, 10 years ago, they came out with a report saying, we need our state legislature to address 50-year-old codes that are holding our small cities and our boroughs in economic crisis 10 years ago. And they made very, very specific recommendations, not for money, for legislative fixes that would take place in Harrisburg. Now, because of the way our communities are cracked out, none of those were introduced, none of those were enacted, and our economy is in worse shape now than it was 10 years ago. So read that. And this one, I've had lots of interesting conversations with past legislators. Our Representative Brian Fitzpatrick talks about the soft and hard corruption bred by gerrymandering. It's a quid pro quo. It's the root of a lot that happens, and I could tell you stories. I don't have time because Ben is here looking at me, so I'm going to skip by some stuff. We are working on a constitutional amendment which would introduce an independent redistricting commission. We are the only democracy, the only major democracy that allows legislators any role at all in drawing their own lines. Malaysia is the only other democracy that allows it. And we believe it's a deep conflict of interest that threatens the integrity of our elections. So we are strongly supporting an independent redistricting commission. That's what Fair Districts PA was formed to do. The bills we support are Senate Bill 22 and House Bill 722. They both have bipartisan sponsorship. House Bill 722, as of today, has 96 co-sponsors. 28 of them are Republicans, 68 are Democrats. It would take away any option of using the kind of data that Michael was talking about. It would have to be a completely transparent process. There would have to be public input, and no legislator or anybody married to a legislator or a lobbyist or paid legislative staff, anybody who's been in political operation for the last 5 years could take part in it. So we're working hard on that. I don't have time to go into the details. You can find all this on our website, fairdistrictspa.com. It's a big change. We believe it would change a lot in our legislative process. We're trying to get this enacted by 2020, when the next the next census is. Actually needs to be in place by 2021. And in that study I mentioned with Catherine Gale and Michael Porter, am I over time? They talk about powerful and achievable reforms. And so some are easy, or none are easy, but achievable. Some are powerful, and they say there's this narrow slice of powerful and achievable. Now, the hard thing is Pennsylvania does not have citizens' initiative and referendum. So we've been told, since we started on this, that actually in Pennsylvania, this is not achievable. It's achievable in the states that do have citizen initiative and referendum. In Pennsylvania, what is the avenue to success? And we are working hard to find that avenue to success. We're not sure we'll find it, but we are going to give it everything that we have. As I said, we've been growing fast. We have a growing list. We've put in place 35 county groups. We're trying to have a group in every county. This says 120 public meetings. It's actually 220. We've been passing resolutions across the state in counties, municipalities. We would love your help to make this happen. And we are encouraging people to think creatively. It will not happen if everybody says, won't happen. But if everybody says, what is one thing I could do, one conversation I could have, one person that has some influence that maybe needs to look at a map and explain why they're this way, we can do this. So that's what we're working to do, and we invite you to join us. And thank you. And Catherine Gale will be at the Pyramid Club on Tuesday, and I will be with her, so come join us. So thanks.
Thank you.
All right. Good evening, everyone. How are you? Thank you for having me. I'm Joel Ross. I'm from the NAACP Legal Defense Fund. The Legal Defense Fund, for those of you who don't know, is an organization founded by Thurgood Marshall over 75 years ago. It's separate from the NAACP, and we primarily are a law firm that does civil rights litigation. I'm going to talk a little bit, well, probably more about the race angle of this than our other panelists. I know Michael obviously brought it up a little bit, and it's a part of redistricting requirements here in Pennsylvania, as it all is nationwide. So I'm going to start with Section 2 of the Voting Rights Act, which is an act that actually applies nationwide. It applies here in Pennsylvania and Philadelphia. It applies down in Alabama and Mississippi. Unlike a different section of the Voting Rights Act, which Michael briefly mentioned, Section 5, which required sort of states to, before they passed any legislation, to receive permission from the federal government before going forward with any kind of redistricting. And the relevance of Section 2 to this conversation is that it was the primary method by which LDF and other organizations in the 1980s attacked what were essentially racial gerrymanders at that time. These were gerrymanders that were done mostly in the South, but all over the country, that were designed to lock black voters out of the electoral process, out of the political process. In Georgia, for example, after the 1980 redistricting, the legislature, the chief architect of the congressional redistricting, said that he didn't want to draw any inward districts, essentially in a state that was 25% black. And so LDF and other organizations brought a series of claims after the Congress amended the Voting Rights Act in 1982, which led to the first black representatives since Reconstruction being elected to not just state legislatures, but also to Congress. So after the 1992 census and a series of victories in the Supreme Court in the 1980s, Congress finally Congress finally became representative, 17 African Americans were elected for the first time from congressional districts after the 1992 census. Before, very few African Americans were being elected. And I say this to give you guys some important context for sort of why these claims are important. We have, in the 1980s and through the 1990s, black voters had to bring lawsuits not against Republicans, but against Democrats. And these are not just Democrats in the Deep South where we think of like Dixiecrats. These are Democrats in Massachusetts, in New York. Cases were brought against them successfully to make sure that black people had representation. And so it was only in the 1990s and the 2000s in which white plaintiffs essentially attacked these majority black districts that were finally electing black candidates of choice, and they attacked them on the grounds that they were racial gerrymanderers. And when I say racial gerrymander, that means that someone has drawn a majority black district, say it's 65%, a majority black congressional district, and the response has been by these sort of reverse racism claims, saying that you've drawn a majority black district, but there's really no saying that the Voting Rights Act is essentially to require drawing a majority black district is unconstitutional. You can't take what was argued in the 1990s and the 2000s was that any effort to take race into account, any effort to draw majority black districts was racially discriminatory. And to bring us sort of ahead to where we are now, after those claims in the 1990s and the 2000s, some of them were successful, most of them were successful, some of them were not. What happened in 2010 is the Voting Rights Act, both Section 2 and Section 5, requires some amount of protection for African Americans. It requires some number of majority-minority districts where they are necessary. But after the 2010 redistricting, when Republicans took control of the southern legislatures, some of them for the very first time, Alabama, where I've done a lot of work, only became a Republican-dominated legislature after the 2010 election and 2010 redistricting there. What happens is that Republicans start to get into the game that Democrats were in for a long time. What they decide is that not only are we have to draw these majority black districts, we're not just going to draw them at the 50% that they could perform at, or in some cases, like in North Carolina, you could draw a 40% black district and still elect a black congressman from that jurisdiction. What they decided to do was to draw 55% black districts, 60% black districts, 65% black districts. And the problem with that is that you're essentially, in the same way that Democrats or Republicans get packed into these partisan districts, African Americans get packed and their communities cracked by these racial gerrymanders. What happens in a place like Alabama, where they adopted an across-the-board 65% majority-minority requirement, is that black people no longer have representation in the state legislature at the same way they did before. No longer are they, 20% in one district of the population, 55% in another district, 30, 40% in another district. Now, black voters are all concentrated into these black districts in which the only people that will listen to them are black legislatures, which is fine, but what we want, ideally from a civil rights perspective, is for people to have the most influence. We obviously like and respect majority-minority districts, but what has happened now in some jurisdictions is that they have become these methods of partisan gerrymandering. And so one of the things with Guilford coming up in the Supreme Court that LDF has been arguing and others in the civil rights community are concerned about is the spillover. So in the 90s and 2000s, as I mentioned, it was primarily sort of these reverse racism claims attacking majority-minority districts, saying you've drawn a majority-minority district and now it is we're worried about it being unconstitutional. We're worried that you've taken race into consideration. We're worried that you've drawn a district that black people are finally getting elected from in a place like Georgia, where 10 years before, no black person had been elected from Georgia in 100 years. And now Democrats are actually using these racial gerrymandering claims. They're using them to say, yes, the Voting Rights Act requires that you draw a majority black district, or it requires that you draw a district from which African Americans can elect their candidate of choice, but it does not require them to draw again, using Alabama as an example, an extreme example, a 65% black district. Using North Carolina as an example, there were black candidates who were getting elected from 51% black districts. So in that case, they argued that all you needed was a 40% black district or a 44% black district in order to elect a candidate of choice. And so what's happening is that Democrats have sort of used these racial gerrymandering claims to, in some ways, impeach the good work that the civil rights community has done, but also in other ways to sort of get around the lack of a partisan gerrymandering claim. And so what we've had to argue, what we are arguing in our Guilford brief and have argued in other partisan redistricting cases, is that any time the Supreme Court decides that they're going to come up with a claim that's viable under the Constitution, whether it's under the First Amendment or the 14th Amendment, what our concern is that race continue to play a role, that race has, that race and the Voting Rights Act is not sort of sidetracked by these partisan claims, that we're not using, that Democrats aren't coming in and using things like the Voting Rights Act and the Constitution to say that drawing a majority black district is problematic. That drawing a majority or drawing a district that performs in some way is problematic. And we want to really take away the power of, what we're concerned about is the power of Democrats to use these racial gerrymandering claims against majority minority districts, and also of Republicans to use racial gerrymanders to draw these majority minority districts that are packed, that look like snakes, that look like Donald Duck, all of these. Unfortunately, I don't have a funny, goofy, kicking Donald Duck image to show you. But the same issues that come up in the partisan gerrymandering context are the issues that are being addressed in the racial gerrymandering context. And what we like to see, hopefully, is to see them be split into separate claims, a claim about race and race discrimination, and claims that address the partisan concerns that obviously not only harm Democrats and Republicans in certain jurisdictions, but also harm African Americans and have harmed African Americans and other minorities for a very long time.
Some of you are very familiar, others not so familiar with the Public Interest Law Center's ongoing litigation about redistricting here in Pennsylvania. I'm going to briefly describe that suit, and then we'll open up the floor for Q&A. So the Law Center in June filed a lawsuit along with Arnold & Porter K. Scholler firm on behalf of the League of Women Voters of Pennsylvania and 18 individual voters, one in each of our congressional districts. This lawsuit challenges that map on the grounds that it is an unconstitutional partisan gerrymander. We filed the claim in state court, raising claims under the Pennsylvania Constitution. The Pennsylvania Constitution is in many important respects more protective of individual rights than the U.S. Constitution. One of our claims involves the freedom of association and alleges that this map was drawn with the intent and the effect of penalizing voters for whom they chose to associate with. And the Pennsylvania Supreme Court has said that that protection is greater under the Pennsylvania Constitution than analogous protections under the First Amendment to the U.S. Constitution. We also raise claims under the equal protection and right to vote provisions in the Pennsylvania Constitution. The basic theory of the case is that this map was drawn with the intent and with the effect of maximizing the advantage for one party at the expense of a different party. We are, of course, a nonpartisan organization. In this instance, in 2011, when the map was drawn, the Republicans wielded the power to draw the map. Had the shoe been on the other foot, we would be doing the same thing right now. And in fact, there are similar lawsuits pending. There's a similar lawsuit pending in Maryland where it was the Democrats who controlled the process and the Democrats who abused their power to draw the congressional districts in a similar way. The lawsuit has been was filed in June. we are going to be in court for the first time on Wednesday, October 4th, 10 a.m. in Harrisburg. We'd love to see some of you there to support. The main issues that are going to be heard at that hearing, one is that the respondents in the case, who include the Commonwealth, the General Assembly, the leaders of both houses of the legislature, the Lieutenant Governor, who's also the President of the Senate, and the Secretary of Commonwealth and Commissioner of Elections, that some of those respondents have asked the court to stay the case, meaning to hit pause on the case, no court proceedings, no discovery, nothing, until the U.S. Supreme Court decides the Gill versus Whitford case that you heard Michael talk about, that case out of Wisconsin about the state legislative districts there. That could mean that our case could be delayed by nearly a year. We have urged the court not to delay the proceedings. The Gill case arises under the U.S. Constitution, not the Pennsylvania Constitution. It involves state legislative districts in Wisconsin, not federal congressional districts in Pennsylvania. And there are a whole host of other factual and legal differences. And even if the U.S. Supreme Court in Gill rules against the plaintiffs and says there's no way you can bring a case like that, that in no way bars the Pennsylvania courts from ruling on partisan gerrymandering claims under the Pennsylvania Constitution. The court is also going to hear a few other motions, including a motion to intervene filed by 34 Republican leaders from various counties around the state. And there are a number of discovery disputes and other sort of preliminary matters that have been briefed or in the process of being briefed. When we get to the phase of this case where we're going to prove the case, there are going to be a lot of interesting things that come out. And one of them will be testimony and expert reports showing mathematically that there's no way to explain Pennsylvania's map other than as having been drawn for partisan reasons. A lot of it is simply just looking at the wacky shapes, but there are ways to quantify that. It's not just a smell test from looking at oddly shaped districts. There, as one of the earlier slides showed, by any number of mathematical measures, we're fortunate here in Pennsylvania to be, number one or very near, very nearly number one in terms of having the worst gerrymanders in the country. If we win this case, we will ask the court to require the legislature to draw a new map, or failing that, to interpose a new map itself. And also, this would set an important precedent. Hopefully, the Fair Districts amendments will become part of our Constitution, fixing the process going forward. But even if not, a precedent from the Pennsylvania courts that partisan gerrymandering is unlawful under our U.S. Constitution will constrain the process going forward in an important way. As mentioned, the mathematical and computer tools have gotten more precise. The data available has gotten bigger, and this has allowed the drawing of maps to occur with greater surgical precision. Someone has commented recently that right now the sort of level of resolution is the block. You used to draw maps kind of by neighborhood. Now you can get down to the block level. By the next cycle, we might be actually going down and cutting across the middle of the block, maybe even cutting an apartment building, having the folks upstairs in one district and the folks downstairs in another, make it three-dimensional. So the level of data just makes even more possible to do this at an extreme level that entrenches politicians, that entrenches certain political parties, and that fosters greater polarization of our politics in this country. So on that cheerful note, would love to open up for questions for our panelists.
So I agree that map is appalling, but I'd like to know what the goal is of fair districts. Is the goal to have statewide proportional representation based on total votes, or is the goal to have each district have the same number of Republicans and Democrats? Because Michael said it's not the shape of the district, it's how constant the district is. And if you divvy up, because we've got Democrats in Philadelphia and Democrats in Pittsburgh, you're going to have spokes coming out of those cities to get proportional representation. That's political gerrymandering too.
Yeah, that's definitely not the goal. The goal is to have an independent redistricting process that produces fair, reasonable maps, that fair in the sense that it represents that community. So for instance, Montgomery County should have a one district, or Erie, who is traditionally, that county spilling out into the counties around them. So it's not that it would be proportionally representative, as you said, that really in a sense deprives communities of representation by drawing in strange ways. The goal is that people will actually know who their representative is, and that those will be districts that will reflect those communities, and that it will open up, it will return us to the need for legislators to actually candidate, to go door to door, to speak to their people. Right now, if you look at that as a League of Women Voters person, how do you have a debate when those districts go all over the place? Who do you call? If you're Montgomery County and you want representation in our state legislature, who do you call? So the goal is to return the maps to represent more closely the communities that they're drawn from.
Yeah,
and to have it be an impartial process.
And if I could just add to that, I mean, I think there are two things that we need to keep apart. One is sort of the litigation, right? Am I supposed to be using this, or am I just supposed to? I'm mic'd up, right?
Yeah.
Okay, I think I'm mic'd up. So the litigation is about sort of when you go too far. So think about it as like these measures tell you shouldn't wear a parka to the beach in the summer, right? But they don't tell you which of numerous things you could wear to the beach that would be totally appropriate in the summer, right? And so within that, there's a lot of room to sort of like, debate about what communities should be, or what communities should be in or out. And the process that Carol has talked about, involves a lot of hearings. It involves a commission that has Democrats, Independents, and Republicans, and they all sort of need to approve the map. And their main mandate will be to sort of try to keep communities together. And they'll hear a lot of testimony. Some of it will be conflicting, and they'll make their best judgment. And that's worked really well in California. Of course, some people don't. You never get everything that you want, but you end up with districts that are really much more representative of what people want. And I'll give you an example in California. So in the mountains in Los Angeles County, there are a number of communities. Some are Democrats, some are Republicans, some are well-to-do, some are really well-to-do. And you never really actually can drive through the foothills, right? You actually would go into the valley. It's sort of hard to drive the foothills. And so they're very, in some ways, and everybody belongs to a community that is like foothills, valley, foothills, valley, foothills, valley. That's just sort of where they go to school, where they shop. And those are real communities. But the people in the foothills said, we want to be in one district. And the question was, well, why? And they said, well, we have one concern that is paramount to us above all else, is fires, wildfires that sweep through. And we don't feel that we get any representation up in Sacramento. We want somebody to sort of represent us. We want somebody to be our voice there. And when the commission drew the district, they actually drew a district that kept all the foothills together. It's sort of a, that was a choice. They could have easily justified doing, foothills, 3 foothill valley districts, but instead they did a foothills sort of district. And lo and behold, when the election comes around, the Democrats running, the Republicans running, all were talking about what they were going to do about fire safety, fire prevention, what monies they were going to get. And that's sort of the way that the process should work out.
Question over here?
Yes, thank you. Thank you all for being here and for your efforts in getting this lawsuit forward. And to your end goal, there are other states who have independent commissions, and there are other states where partisan politics come into those independent commissions. I think Arizona is a good example. I personally don't think you're going far enough, and I think you should be using computer models for redistricting. And I just how do you prevent that type of partisan politics coming into independent commissions, moving forward?
Well, so I would say that Arizona is not as independent as California. At California, it's pools of candidates who are vetted not to have connections with to have been elected. So it's the pools are independent citizens, although everybody's political, we know that, and so people, they will have their thoughts and opinions. But then those are chosen randomly, and as Michael said, you'll have the way our bill would be written. You'd have 4 from a Democratic major party, 4 from one major party, 4 from another major party, 3 independent or third party. So you'd have 11 people. 7 of them would have to vote together to approve a set of maps. So you'd have to get somebody from each of those pools to agree that that set of maps was appropriate. And you would not be allowed to use data, and that's a big piece of it. You wouldn't be allowed to sit down and say, we know this is a Democratic neighborhood, this is Republican. You wouldn't be allowed to use any of that. Everything used would have to be transparent, so if Michael wanted to come and say, I need to see that computer, all of this is done by computer, so it will be done by computer. Ask anybody involved and they'll say, there need to be humans to put the parameters into the computer, and there need to be humans to evaluate the maps. And so there would be humans doing it, but if Michael came and said, I want to see what's on that computer, he would be allowed to see it. It would be transparent. The computer programs would be transparent. So you will never get something that's perfectly independent of politics. We know that. But you can take the personal motivation and the deeply partisan motivation and get something that's much, much more fair. It might not be totally fair, and there might be people who don't agree, but it will be a long, long way better than that.
And it's much more, it's sort of really like a jury in a lot of ways, right? I mean, we don't expect jurors to come in and be blank slates. We expect them to bring their life experience and all of that. But you don't want like the people who are going to be like, I'm going to, like the cops are always right, or like, the cops are always wrong. You want sort of people who are going to be fair-minded. And the California system goes a long way to doing that. You have to write 5 essays to be on the California Commission. You go through an extensive interview process, and then you're put on this list. And the legislative leaders get to strike people off. They get to say like, oh, I think Carol, she's like a total patsy. She's not really independent, right? And they get to strike people off. But they don't actually get to pick. And that's different than Arizona, where the people actually get to pick. So if I wanted a patsy, I could say, Carol, apply, and I know you're going to make the list. I'll pick you off the list, right? And that's Arizona. California is different in that sense. The California Commission also has a big advantage in it that it's larger, right? The Arizona Commission is 5 people, 2 Republicans, 2 Democrats, 1 independent who's the chair. That leaves you much more subject to, a bad actor, right? The California Commission is 14. The Pennsylvania Commission would be 11. Even if you get 1 rogue actor, it's likely to be sort of balanced out a bit. And there's much stronger transparency provisions. Pennsylvania is going to be much more like California. To this day, you can watch, if you wanted to. I'm not suggesting that you do, but you can watch every single hour from the selection of the people to interview all the way to the adoption of the final maps in California. It's all available. It was all done on public access TV live, and many people would email it and say like, gosh, Carol, did you know about this about Carol? They would, if people actually did watch this. I don't know what kind of people do that, but they did. So there are a lot of structural things that you can do, and I think the Pennsylvania proposal is a really strong one. So.
Could you turn your mics up?
Okay.
We can't. They can.
Can they?
The mic on you just goes to this.
So maybe.
Okay, so we should
Your
just
outside
speak into
voices when
these?
you.
Okay, can
when
we
you
use
talk.
this?
Yeah,
Need to speak into this too?
Okay.
You have to turn it on.
Okay.
Other questions? We have a question over here.
For educational purposes, it would be helpful to see a more idealized map. And in looking at the criteria, it's hard to believe you could still maintain contiguity and compactness in Pennsylvania.
Amanda Holt, the piano teacher, drew there was a lawsuit in 2011 on our state legislative maps because our state constitution says you can't divide more than mathematically necessary. And so she just made her own maps and created 3 sets of maps that showed that the maps as drawn had 10 or 20 times more divisions than you need to do just as a piano teacher sitting down there in the evening doing this. The committee of 70 folks are here. They're going to be launching, am I allowed to say this? They're going to be launching a program called Draw the Lines, which will be giving the tools to high school students, college students, citizens to draw maps so that people can see anybody with a little bit of training can take the data we have and take the maps that we have and draw things that are much, much more fair. The great advantage of that, whether we get the amendments through, whether we get the lawsuit through, we are going to have educated citizens on this the next time around, and they will not get away with this the next time around because people will know there's no reason in the world for maps that look like this.
We have time for one more question, but before we go there, just wanted to plug, we have the lawyer for Amanda Holt from that case sitting in the front row, Michael Churchill of the Public Interest Law Center. We have one more question.
Maybe we could take two, and
Okay,
we
well-
could 2 or 3, and we could answer.
Okay, we'll do
Yeah.
rapid fire Q&A. Yes, ma'am.
The Pennsylvania Constitution has been broken in the last several redistrictings because when they were appealed, the redistricting was appealed to the Pennsylvania Supreme Court and to the United States Supreme Court, and the Pennsylvania Supreme Court didn't said, oh, it's fine. Why? Because they're elected judges. And they're partisan to begin with. And the Supreme Court decided that the map back almost 20 years ago was okay because it didn't mess up races. There was no racism attacked, only partisanship. So we really must have an independent commission. No question about it.
Thank you. Mr. Joseph.
So what is obvious is 13 to 5. Is there any part of this that says that anything, say, less than 12, well, my math is, 9 would be obvious, but how about 11-7? Is there some way of making sure that
Yeah.
the parties are fairly distributed?
So these mathematical tests, as I said, they sort of tell you when something isn't likely to be random, and what they do is they say like 13-5 is like not random, given that Pennsylvania is like 50-50 in almost everything, right? Donald Trump narrowly won, but you have Tom Wolf, and so they don't really sort of set a clear parameter. It's sort of, even at 11-5, you sort of have to depend on like how you, like what each party gets in the districts or something like that. But they can tell you sort of, that 13-5 is wrong, and then what you would do is you would test any hypothetical map against that. There's a lot of flexibility. It doesn't have to be, and I'm going to mess up the math with 18 districts, but it doesn't have to be 9-9. It doesn't have to be, 10-8 or anything like that. There's not any, there's a lot of room for fair sort of negotiation and things like that. So, for example, you might choose, as the commission or the legislature might choose to create more competitive districts, or it might choose, which would sort of alter the balance, or it might choose to create more safe districts. All of that is sort of safe within the outer bounds that are established by these mathematical measures.
We have time. Do we have time for one more question, Karen? Okay,
One more.
back row.
Okay, I promise. In all the various cases that are out at the federal and state level, have the opponents of gerrymandering reform revealed a credible defense at all?
Their argument is sort of like, well, I mean, they have a couple. One is, they have several. One is, we've always done this, so why is it a problem? It can't be unconstitutional because we've always done it. Now, never mind that we also had segregation and we didn't allow for same-sex marriage, but let's set that aside. They also say all the Democrats live in places like Philadelphia, and that's what creates the problem. But as we see, like this only occurs in battleground states. Pennsylvania is not Nebraska, and so that sort of doesn't actually work out. And lots of people have sort of disproven that in their hypothetical maps and things like that. The other, sometimes they say, especially in the South, is, oh, we created all these Voting Rights Act districts, and that's what's creating this problem. But the reality is creating the Voting Rights Act districts in the 1980s and the 1990s actually created more fairness, because before, Democrats were underrepresenting two groups, Republicans and African Americans. And when you drew these minority districts, you created more opportunities for Republicans, and you also more fairly represented African Americans. So they don't really sort of have a great thing, from an evidentiary standpoint. I guess their moral argument is like, this would just be really big and intrusive, and have the court involved in every map, and you don't want to do that, court, and that's an insult to sovereignty. My old home state of Texas, they say like, well, gosh, you can't mess with us. And so that's sort of, it's a hodgepodge. It actually isn't necessarily that coherent.
Yeah, I was just going to add, I think it's funny that when you attack the districts that are majority black, the argument is always that it's partisanship, right? And then when you attacked districts based on partisanship, the argument is that, well, the Voting Rights Act made us do it. So it's sort of, it's a funny that they jump back and forth between what justification they're using at any given time. And I also say one other thing just about these maps and the districts that get drawn both here and in other places. Even when you don't take into consideration something like these very sophisticated computer models that folks are using now, race is a very clear indicator of how someone will vote, particularly amongst African Americans and other people. And so that is part of the reason why they are often targeted, is because you know, African Americans 90% of the time are going to be voting for a Democrat, right? And so whether it's beneficial to you to spread them out or to split them up or to pack them, that happens. And so this partisanship, the connection between partisanship and race, the way in which one gets used to defend the other, is an important part of all of this litigation.
Thank you, everyone. Chair Vaughn.
Well, good evening, everyone. I hope you can hear me. My name is Karen Jackson Vaughn, and I am co-chairing the Communications Committee of the Board of the Public Interest Law Center, along with my wonderful co-chair, Phil Wilson. My charge at this point is to move us very quickly to the next phase of tonight's program, but I wanted to begin, first of all, by saying thank you again for joining us. You have been a wonderful audience, and I would ask, once again, for a very robust round of applause for this wonderful panel that's given us a rich and informative educational program tonight. Always we have some housekeeping matters. You do have evaluation forms. We really would appreciate it if you would fill those out. And I understand for those of you who are trying to get CLE credit, you absolutely must fill them out. And this gentleman at the back, Michael Burton, will take those, or as you go out, once we need to go down to the reception, you can leave it at the desk. So the Communications Committee really works very closely with the staff at the Public Interest Law Center, and our goal is really to raise the visibility of this wonderful organization in the community at large and to help to expand our brand. So about a year ago, we realized that we're living in a digital age, so it's time for us to do some new things in terms of sharing our story. And we settled on creating a short film about that. So we are very pleased to announce tonight that in fact we have completed that project, and we have a wonderful, polished, professionally made product to share with you. And also, although this has been a collaborative effort, we realized we needed to get someone who was a professional, somebody who's well known within the film community here in Philadelphia to work with us. And we found a gentleman who turned out to be the right person. This gentleman is both a writer, producer, and director. You may be familiar with his work because if you've seen the documentary Philadelphia, The Great Experiment, he was the lead person in that. And his name is Andrew Ferret. And we'd like to ask you, since he's at the back of the room, if you would give him a round of applause as well. To join us in sharing our appreciation for his work. Now with that, I'm going to ask my co-chair Phil to come up and start the film. And we look forward to your paying close attention and any feedback that you would like to share, we'd love to hear. Once again, thank you for coming.
We're okay?
You should see it, right?
Yeah, that's great.
Yeah, okay. We'll just.
Post notification.
Oh,